Going to finish up today with the lecture on criminal law. Then we're going to talk about this U.S. versus Carpenter case some, and then I have a couple other things, and we'll be good. You have a quiz that's due Monday, and you have a discussion question for this week that's due at the end of the semester. I have been getting some emails and texts that people are trying to schedule their interviews, and they're having some problems with that. Has anybody finished that? I know Mr. Janeway has. Anybody else finished their interview? Okay. Has anybody tried to schedule it and not been able to? Has anybody tried to schedule it? All right. Yeah. Please get on that. There's something about they took down the link to schedule it and said email us or something. And if that's how they're going to play this, then that's not going to work. But I need to try to get in touch with them too. I'm wondering if they I thought maybe it was because they had gotten a rush of emails and they had too many, but clearly they don't have a rush of emails if none of y'all have tried to schedule. So I don't know. So the people that did your interview, they were people here? Yes. Oh, okay. I thought it looked like the link was somewhere else. You finished yours, Shahid? Oh, you've already done it? Yeah, I've done it. Okay. So you got proof that you did that. All right. I'll accept that. So please don't wait till the end, because I'm worried that I don't know, I'm worried that they're not going to have the capacity or something. So. Because the school wants y'all to be better prepared for your careers. And they want you to have practiced done interview practice before you actually go and do interviews. Because the flip side of this was that the feedback that we were getting was that from employers was that people were not prepared or not as polished as they would have expected them to be. So we're responding to the feedback we're getting by trying to get y'all more practice so that when you do go, you've got a resume that's, looks good and all that kind of thing. I mean, I have done this in the past, Kim, where I've asked you to turn in your resume to me like I am now, and I was trying to be the one to help you with it. And there are a lot of really good resumes that I get, and there are a lot of resumes that I get that I'm like, please tell me you did not send this to anybody. Please tell me you did not put Columbus State University Business School on here, because it looks like a third grader did it. So some of it is just making sure that the people who are less responsible, are getting it done. But that's a good question, but that's why we're doing it. Now, why it's a part of business law, that's a mystery, but it is. So here we are. All right. On Tuesday, we talked about just kind of criminal law in general. Gave you some examples of crimes, how they're defined, how they're proven. We talked about some defenses to criminal liability. Again, these are just examples. There are a number of crimes that we're obviously not talking about. There are defenses that we're not talking about, but I just wanted you to sort of see how those operate in real life. And on Tuesday, we talked a little bit about putting ourselves in a courtroom and imagining how these would play out from an evidentiary standpoint. What would have to be proven? What would the evidence and testimony have to be? What would the jury have to decide in cases like this? So today I want to get into a little bit of constitutional law as it relates to criminal law. So we're slipping back to the U.S. Constitution here for a little while. Now we'll talk about the Fourth Amendment, the Fifth Amendment, and the Sixth Amendment. The Fourth Amendment is the protection that we have against law enforcement or any governmental entity conducting an unlawful, unreasonable search and seizure of our person or our property or anywhere that we have a reasonable expectation of privacy. Now, I want you to think about this for a second. When this amendment was written, the text says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause. So from that, we get that our persons, our places, our private things cannot be searched without a warrant. How does that work? The way that works is law enforcement goes to a judge. This is not in a courtroom and with both sides present. Lots of times they're calling up the judge in the middle of the night. They may stop by the judge's office and they say, Judge, here's a sworn statement. This is the evidence we have that gives us reason to believe that what we're looking for is in this place we want to search. And if the judge believes that the evidence is reasonable and that a reasonable person would, it's more likely than not that they'll find what they're looking for, the judge will issue the search warrant. If law enforcement doesn't have a warrant, they can't do the search. Now, when this was written or adopted hundreds of years ago, there were no cell phones, no computers, no cameras, nothing electronic. We were thinking about more in terms of being safe from our houses being searched, maybe our pockets being searched, our bags being searched. Nothing like where we are today. The Fourth Amendment still protects our phones and our computers and our cars and things like that. We've just had to have the law evolve over time to include these other places where we have expectation of privacy. So you'll see when we talk about the Carpenter case, we get into a little bit of how that interpretation has evolved. But the Fourth Amendment protected against unreasonable searches and seizures. There are two ways to challenge a search on Fourth Amendment grounds. One is if the search occurred without a warrant. That's a violation of my Fourth Amendment right. We could argue about what is a search. We'll talk about that a little bit more in a minute. The other way to challenge it is, let's say that law enforcement did go see a judge and did get a warrant. I could still challenge the sufficiency of the evidence that they used to get a warrant. Yeah, you got a warrant, but you really didn't have a reasonable basis for it. So there is some review of that. It's not like a law enforcement can just go to the judge and say, hey, judge, we got this anonymous tip that Tebow's dealing drugs out of his house. So can we have a warrant to go search? That won't hold up. Courts have said they've got to be, when they go to get that warrant, their sworn statement has got to have things like the background circumstances, the reasons why they believe that a search will turn up what they're looking for. So, for example, let's say that in the example where they just got a tip with nothing else that they need to search my house, that probably wouldn't hold up. But if police suspected me of dealing drugs out of my house and they did a stakeout and sat in a police car, undercover car across the street, and they noticed people coming and going from my house at weird hours, that they noticed the odor of meth, which I don't know if that's a thing. I was going to say the odor of marijuana, but that would be marijuana use, not necessarily dealing. That they noticed equipment that's associated with drug production. They noticed all this from a public vantage point, okay? They haven't gone in my house or anything. If they go see a judge and say, Judge, we got a tip, but we also, based on that tip, we staked it out. We saw people coming and going at times that are consistent with some illegal activity. We smelled the odor of illegal activity. We actually visibly saw from the street some equipment that is indicative of drug dealing, then that would be enough to support a warrant. So you can't just say we got a tip or we think it's in there. You got to say what that's based on. You got to be able to tell the judge the credibility of the tip, the credibility of the person or the evidence. So you can't just say that. Now, in practice, do I think a lot of search warrants end up being like 2 a.m. phone calls? Hey, judge, we got a tip. We believe this. Fine, you can have a warrant. Bring it over. I'll sign it. Yeah. But if that happens, then it's up to the defendant after the fact to challenge the sufficiency of the warrant. So those are two ways that you could challenge or uphold Fourth Amendment rights when it comes to searches and seizures. The other change that I think really is obvious and apparent to us that wouldn't have been to the people who wrote this are that I could sit across the street from somebody's house, right? And I can watch the comings and goings. There's nothing intrusive about that. But I could also use technology to penetrate the walls and the secrecy and the privacy of that house. I could use technology to map it out, right? Somebody told me in the earlier class, they could map out your house using data from the router, your internet router. I don't know how all that works, but I believe it. I could do a heat map of your house using thermal imaging without setting foot on your property. That is much more like an invasion of privacy. That is much more like the type of thing that would need a warrant than sitting outside and watching the comings and goings. Right? So the Fourth Amendment has come to be that it protects people and the areas where they might expect privacy rather than places. I mean, it does protect places, but when it first started, when it was first written and passed, it really protected places more than people. Now we think it protects people more than places. There was a case on the thermal imaging, a Supreme Court case from the 80s, I think, where the police suspected that the guy was growing marijuana, had a grow house, and they did a thermal imaging heat map of his house, and they could tell from that the heat was coming from the basement, that it was concentrated in an area, that the levels were indicative of not normal household use. They were consistent with heat lamps and things that you would use to grow. And they used that evidence against the guy. But they did not have a warrant to do the thermal imaging of the home. And so the defendant challenged the sufficiency, or challenged it based on that constituted an unreasonable search. And the Supreme Court agreed and said that was an invasion of privacy. It was an intrusion into a place where we would have a reasonable expectation of privacy. And that if the government wanted to do that, to thermal map a house, they needed to do what? Just get a warrant. A lot of these problems with the Fourth Amendment would be solved if law enforcement would just get a warrant. There are exceptions. And I don't think that I test you on this level of detail. So you're fine to just listen to this part. But there are important exceptions you need to know. One is that if the evidence that the police want to get is in plain sight, they don't need a warrant. So they pull me over for speeding, and I have a brick of cocaine on my passenger seat that is wide open to anybody who looks in my window. You don't have to have a search warrant for that. If you give consent to law enforcement to be searched, they don't need a warrant. So if they come up to knock on my door and say, may we come in and have a look around? And I say, do you have a warrant? And they say, no. And I say, sure, come on in. Then I have waived my Fourth Amendment right. So consent waives that. That's important for you to know. In the business context, I own a store. The public is invited into my store. Let's say it's a grocery store. So I don't really have a reasonable expectation of privacy in what's on the shelves in my showroom. But I do have a reasonable expectation of privacy in my office, in my warehouse, maybe, certainly on my computer servers. I have a reasonable expectation of privacy in the footage that my security cameras generate, my servers, things like that. So you do have to be careful. If it's part of the public, it's already public, then they don't need a warrant for that.
What if they have a warrant, but they get the wrong place? Like, they have a warrant for one house, but they get the next house over there.
Question is, what if they have a warrant, but they went to the wrong place? Great question. And that leads me into my next point. Any evidence that's obtained without a warrant where they should have had a warrant cannot be used. So in your example, they could not use that evidence that they got from searching the wrong house.
No, but like they have a warrant to search a house or arrest somebody, but they get the wrong house and then they break the door. Do they have to pay for the damage?
Oh, do they have to pay for the damages to that? If they break down your door and it was an accident, they have to pay for the damages to that. Yeah, I think they do. I think they do. I think they do under a negligence theory. They've got a duty to execute warrants correctly, right? They were negligent in going in the wrong place, and the breach of that duty resulted in damages. Resulted in property damage.
I've heard one stories where they go to search, they have a warrant to search one house, they break down the door to their house, and then it looks like they cause a lot more damage. Like they also go out the door. They also, it was one story, they caused emotional damage to like a family.
Oh yeah, can you imagine police kicking down your door? But under tort theory, you'd have to sue the city for that. They have some immunity, so that's a really interesting question. But I'm pretty sure that they would be responsible for that in that situation. So good question. So leading to the point of, if any evidence that was required, that there was required to be a warrant and it was gained without a warrant, can't use it. It's called the exclusionary rule. And if the search is bad, then any evidence they get is out. Say that they searched my house without a warrant, or they searched my car. No, they searched my house without a warrant. And they find illegal guns, that I'm dealing drugs. They seize my computers. From my computers, they find all this financial crime, and they use that evidence that they got to arrest and charge all these other people. Not only can they not use that evidence against me because they didn't have a warrant, but they can't use it against the other people either. If the warrant is bad or if the search is bad, all evidence is out. That's called fruit of the poisonous tree. The tree's bad, any of the fruit, any of the evidence, anything they get from that is out. That is Fourth Amendment protections. There's also an exception to a warrant on a car. They can search your car without a warrant in a lot of circumstances. That's because, as a practical matter, if they said, "See you later, we're going to go get a warrant," you'd be gone, and the evidence would be destroyed and all that. So they're able to, in emergency circumstances, like for safety reasons or to keep a suspect from getting away, they could also search somewhere without a warrant. Say I robbed a bank and I ran into the business next door and I locked myself up in there. They could come in there without a warrant because of the emergency circumstances. So it's a lot of times we sort this out on the back end. Police do what they've got to do, and then later on we figure out whether or not what they did should have had a warrant or whether or not it qualified under any of the exceptions. I mean, again, just like we talked the other day about self-defense. You don't get to call time out and assess the situation necessarily, right? You do what you got to do, and you make judgment calls as you go. And sometimes you're right, sometimes you're wrong. The Fifth Amendment has some protections for us that are important. One is due process. That's a phrase you hear a lot, gets thrown around. It's an important phrase. But what it basically means is that the law has to be carried out fairly. Okay? If the police arrested me and didn't tell me what I was arrested for, that would be a violation of my due process rights. If I was convicted without a trial, that would be a violation of my due process rights. If I was not allowed to cross-examine witnesses at trial, that would be a violation of my due process rights. If I got charged with a crime that doesn't exist in statutory form, they're just making it up, that would be a violation of my due process rights. If I get charged with a crime for something that wasn't illegal when I did it, but it's illegal now because a law was passed in between the time, that would be a violation of my due process rights. So that's a very short phrase with a whole lot of meaning that can be applied in many ways. Fifth Amendment guarantees us due process of law, which is that the law will be executed and implemented and enforced in a fair way. Kim.
So say somebody gets arrested for possession of marijuana, but then the liquor law, or not liquor law, but the liquor store is legal, do they still have to do the time in prison, or do they not?
Oh, good question. So the question is, for my video people, somebody is convicted on marijuana charges. It's later becomes legal. What happens then? They're still convicted because it was illegal when they broke the law when they did it. Some people, though, I think, as a practical matter, that are serving prison sentences may be eligible to have them be commuted because what they're serving time for isn't illegal anymore. But it doesn't undo the past. It doesn't undo the fact that they were convicted of breaking the law at the time. I doubt there's people, the people who are in prison for long periods of time, that kind of stuff is probably not going to be decriminalized. You know, the trafficking, the dealing, the possession of large amounts. It's the smaller stuff that I expect in the next few years will get decriminalized. It's decriminalized here unofficially in that we have a district attorney's office that isn't prosecuting or says they're not prosecuting minor possession crimes. So even though it's illegal, it's on the books, they're not actually enforcing it.
I think it'd be kind of hard to get anybody with having cannabis that has THC in it because the THC is illegal, but the CBD is not.
Well, that and then you've got the Delta 8 that's legal with that
Smells the same, looks the same.
whole, or do I have it backwards? Is the Delta 8 legal or the Delta 9? Anyway, there's a loophole on some of that stuff. And I think that local law enforcement, probably law enforcement in a bunch of places, has just decided we're not going to use our resources on that. I mean, I think they're more worried about the trafficking and the large scale distribution operations and that kind of thing. Other Fifth Amendment protections would be the protection against double jeopardy, we call it. You can't be charged or tried for the same crime twice. If I'm charged with murder, I go to trial and the jury says I'm not guilty, they cannot come at me again. But I still could be subject to a civil suit, like the OJ case. The state of California charged him with murder. He was found not guilty. They couldn't go at him again for murder. But the families could go at him again in a civil case because that's not a crime. That's tort. They went after him in tort law. let's say that the police raid my business and they charged me with running an illegal gambling ring. They also find evidence that I'm smuggling guns. I don't get charged for any of the gun stuff. They try me on the gambling charges and I'm acquitted. I get off. They can't try me again on the gambling charges, but they could then bring gun charges because I haven't actually been tried on them yet. So double jeopardy applies to the exact same crime. The other Fifth Amendment protection is against self-incrimination. So this is, you all have heard this. I plead the Fifth, I take the Fifth. It means that they cannot force you to testify against yourself at trial or to answer questions from law enforcement that might incriminate you. The government has to prove their case against the defendant. They can't use the defendant to make their case. That's a right we have under the Constitution, the right against incriminating ourselves. Miranda rights, y'all know about those. Those are actually not found in the Constitution itself, but they are. The Supreme Court found that the Constitution does require that law enforcement read a person they're arresting their Miranda rights, which is you have the right to remain silent, you have the right to an attorney, all those things. They do?
Yeah, so that if you're questioning.
Because you were an MP, right?
If you're questioning about it, you have to show that you did it correctly.
Right.
So you know you did it correctly. Right.
I read it right off the card. Gotcha. What about, did y'all have body cameras?
Some places, depending on the budget.
I feel like that probably sorted out a lot of disagreement. I mean, like you either said it or you didn't, or you did or you didn't. Did you behave differently with a body camera than if you didn't?
No.
Were you conscious of it? Like, oh, I got the camera on today?
Yeah, try to swear less when you're talking to your partner in your car.
So you're more worried about what your conversation is?
Yeah, when you're just sitting in your car, yeah.
I saw an article this morning about the new National Director of Intelligence firing people for having dirty chats on the intelligence server or whatever. And the people were like, yeah, we shouldn't. I mean, that's not really what we're there, but we're locked in some bunker for hours or days at a time and shielded from the world, listening to eavesdropping on people, and we're just chatting with other people to pass the time. Anyway. So that is what I wanted to talk about for constitutional protections. Let's move to the Carpenter case now for a second. So this case was decided by the Supreme Court in 2018. The facts that led to this case happened way back in 2011. So it's still fairly recent case, fairly recent decision. And Mr. Carpenter, who knows what Mr. Carpenter did? What was he convicted of? Robbery, right? Bunch of armed robberies, right? How did they nail him? What does CSLI stand for, Ethan?
Cell site location.
That's right. It's hard to say. I want to say CSI or something. CSLI, cell site location information. All right, and what is CSLI? What is that exactly?
Kind of like how you get your location, like from certain cell towers.
Right. Okay. It is the information about your communication with the cell tower that can then show your location, right? Say that right? Is that right, Ryan? Some geolocation. So, right. So, there was some, and this is a great example of how the law has to evolve. I mean, there's no way that CSLI was anything that the founding fathers could have been thinking about when they passed the Fourth Amendment. Right? They couldn't even have fathomed that. We couldn't have probably even imagined CSLI 40 years ago. Just not there. And so we had these lines of cases that we had to sort of reconcile and fit this situation into. We had, the article talks about some prior cases that dealt with third-party business records, like bank statements, or law enforcement using a PIN register, which just recorded somebody's outgoing calls. I guess it's like tapping a phone, not for content, but just for the digital, for the information. I don't know. Y'all correct me if you know more about it than I do. But point being that, go ahead, Ryan.
For tapping a phone, that's specifically referring to putting a wire receiver in an actual phone.
What's a PIN register? What's a PIN register?
PIN register?
Okay. Which is,
you can't check the logs of the calls and the text from the carrier.
oh, you can. Okay. Yeah. So the Supreme Court had been faced with this question before. Does law enforcement need a warrant to access things like bank records or call logs? And the court found that they did not. The reasoning behind that was, we don't have an expectation of privacy in that. I know when I'm doing business with the bank, they're the ones keeping the records of it. I'm swiping debit cards that are theirs. I'm using my account. I mean, my account is housed by them. I know that that is not private information necessarily, what's on my bank statement. For call logs, I'm using Verizon to make phone calls from my cell phone. I'm doing that. I'm putting that out there. Okay? I don't have a reasonable expectation of privacy in that, said the Supreme Court. The third-party business records doctrine. Okay? We also had this case called U.S. versus Jones, where law enforcement put a geolocation device, a GPS tracker on somebody's car, and mapped where they were going using that without a warrant. And the Supreme Court said in that case, you do need a warrant to do something like that. Okay? So we've got these cases where we don't have a reasonable expectation of privacy when we voluntarily put information out there. We do have a reasonable expectation of privacy in the government tracking our every move through GPS. And then we got this case, CSLI. It is somewhat like the third-party records stuff. I do make some calls from my phone voluntarily, right? I do text other people. I cause my phone to ping that tower. But it's also a lot like the geolocation stuff in that it maps out where I've been. So the judges are having to kind of grapple with these two precedential lines of authority. One about the third-party doctrine, we're kind of like that. And then we've got this other with the GPS stuff, and we're a lot like that. Where did the judges come out on this? Is this more like the third-party records doctrine, or is this more like the GPS case? What did the judges say? What did the Supreme Court say here? They still need a warrant. In other words, this is a lot more like the GPS cases. So when you get to that part of the, so basically, let me back up for a second. Mr. Carpenter was alleged to have been involved in all these armed robberies. And the government went to his cell phone company, and asked for 7 days of CSLI for his phone. And without a warrant, that was legal. There's actually a law that said that they could do that. They got it, and then they mapped out, based on time and location, exactly where he was for those 7 days. And lo and behold, that put him right at the location of all these robberies at the time that they occurred. So that was the evidence that was some of the evidence that they used to convict him. So at trial, he would have said, hey, I think that you should have had a warrant for that. I think that really is a search that requires a warrant, and so you didn't get one, you can't use that. The government said, yeah, we can, we always have. There's a law that says we can get it. It's never needed a warrant before, why would it need one now? Trial court agreed with the prosecution and allowed that evidence in without a warrant. Carpenter appeals. The appeals court says we agree with the trial court. They didn't need a warrant for that. He appeals to the U.S. Supreme Court, and we get this decision where they said, yeah, in the past we have held that you don't need a warrant for this kind of stuff. Or no, we haven't held that. It's been allowed by law. But now we are finding that this does constitute a search. So when the court starts going through their rationale, they talk about how when the Fourth Amendment was passed that it protected places really more than people, but now we've kind of flipped that to protect people more than places. Chief Justice Roberts also noted that the development of technology has required the court to find ways to preserve privacy, where surveillance tools have enhanced the government's ability to encroach on areas normally guarded from inquisitive eyes. He talks about the thermal heat marijuana case here. And then he goes on to talk about how the mapping that they can do with the CSLI is a lot more like the GPS system than it is just the third-party business records, which we've talked about. He does say, though, that he's really careful to say, that in this case, the government had how many days of CSLI? 7, right? So he's really careful to say that we're only saying today that 7 days worth of CSLI needs a warrant. We're not saying anything less doesn't have to or does. We're only saying 7 days constitutes a search. So my question is, what if, let's say that they had gotten 2 hours worth of CSLI? We go to trial. Carpenter says, should have a warrant for that. If we're the government, what's our argument that we didn't need a warrant? Using the rationale the court used here. Say that again, Kim? Well, they said 7 days, right? But because 7 days told a story, right? 7 days mapped out. The court says you can tell somebody's familial, professional, political, religious. All those are things you can learn about somebody from mapping out their whereabouts over a 7-day period. For 2 hours, what's your argument then? I'm not saying that you have to agree with the argument, but what is the argument? Anybody want to make that? How about 7 days is, I know it's harder because we feel that the other argument's better. 7 days tells a story, but 2 hours just tells a snapshot. I mean, that in no way is a narrative of what I did over a week's time. And the court was concerned about that being an intrusion into my life of, basically tracking me for 7 days. 2 hours? Snapshot. I may not even leave my work. I may not even leave my home. What can you tell about me over 2 hours? I don't think that's a great argument. I'm like Ryan. I'm ready to make Carpenter's argument. 2 hours could still tell you all those things that 7 days could, right?
The only thing that I could think of for checking for 2 hours is if they didn't initially suspect the person of having committed the crime.
So the basis for their asking for it. Yeah. But that's sort of after the fact.
Expected it to be incriminating evidence that would
So yeah, whether you found it or not, it's still, I mean, the question though, from a constitutional standpoint is the search itself, notwithstanding what it found, was the search one that needed a warrant? I think mapping out somebody's whereabouts over 2 hours, I'd rather make Carpenter's argument on the 2 hours than the government's argument. But I do think it is not quite the same as 7 days, but I mean, if I was law enforcement from here on out and I needed CSLI, I would just get a warrant. Because the risk is if you don't and you find the evidence and you want to use that, and then it gets challenged and the court decides that you did need a warrant, then you can't use it. So just get a warrant. Just do your due diligence and get a warrant. I don't know. I've never really looked, but I need to see if there's been any other challenges on Fourth Amendment grounds to CSLI on time periods that are less than 7 days. I mean, clearly anything more than 7 days, the government wouldn't have an argument on that. 7 or more, but less possibly. I don't know where the line gets drawn though. I mean, 7 days, 6 days feels like 7, 5 days feels like 7. I mean, you know, where do you draw that line?
The reason why I brought up whether they be suspected of committing a crime would be more along the lines of if they're trying to locate somebody for, let's say they're lost or in the woods or something.
Oh, I see what you're saying.
Like that, but you may find out in the process of that they had committed.
Because there was something about that specific time period that they were looking. I gotcha. I think that could, that could change the argument some. I'm just like, just get a warrant. But, you know, we wouldn't have had this happen in 2011. Supreme Court decided in 2018 would have 7 years of litigation. Mr. Carpenter probably served all of his sentence by 2018. I don't know. Well, I don't know. For armed robbery, he may have gotten more than that amount of time. Anybody have any questions on the Carpenter case? Or you do have, there are several questions on your quiz about the case. So if you haven't read it, please do that. Pull up for a second, for the time we have left, the criminal statutes that are posted to the content module. These are examples of Georgia criminal statutes. And take a quick second, read the battery statute. All right, so in all criminal statutes, you're going to see a mens rea, the required mental state, and you're going to see the actus reus, the prohibited activity. So under the Georgia battery statute, what is the mens rea for battery? What's the mental state that's required to be convicted of battery? Ryan? Intentional, that's right. That's what it says there, intentional. Remember, we can have intentional, we could have reckless, we could have negligence, we could have strict liability. This is an intentional crime, requires intent. What is the prohibited activity in the battery statute? Go ahead.
Substantial or visible bodily harm.
Right, causing substantial physical harm or visible bodily harm to another. All right, so if we're in the courtroom, the prosecution, the DA, the plaintiff, is going to have to prove that the defendant intentionally did it and that the actions caused substantial physical harm or visible bodily harm. So if we're the defendant's lawyer, where are the places that we would be looking for weaknesses in the prosecution's case?
Whether or not there is photographic evidence of the harm or
Yep.
medical records.
We'd be looking at whether, we'd be arguing that there wasn't physical harm, or if there was, that it wasn't substantial. Right? That's a word in there that they got to prove. We can argue about that. We could argue about whether the bodily harm was visible. Although, I mean, we can still argue about that. Sometimes it'd be obvious, sometimes maybe not. But these are places where the defense would try to poke holes in the prosecution's case, in both the mens rea and the actus reus, that it wasn't intentional or that it wasn't substantial physical harm or visible bodily harm. Scroll down to the robbery statute. And don't worry about subsections B and C. Just read A, 1, 2, and 3. All right, what's the mens rea state of mind for robbery? Intentional, good. That's right. What is the prohibited activity under the robbery statute? By or sudden snatching. That's right. So there are some different ways that we could do that. That is the actus reus. Where are some places where you might poke holes in the prosecution's case or look to poke holes? Janeway.
Didn't intend to steal something.
All right, the intent to commit theft. You certainly attack the mens rea there. Use of force, depending on what it was. I could come up with a fact pattern that's questionable. If the allegation is the use of threat or coercion, or by placing a person in fear of immediate serious bodily injury, that feels like some places we could argue. Sudden snatching. I mean, we might could argue about that. What exactly is snatching and how sudden are we talking, right? Well, that's what I'm thinking. I'm just going to mosey by over there and pick up Xavier's secret. I mean, real slyly take his laptop. So those are just examples of.
I have a question.
Yes, sir.
What does it mean by what the immediate presence of another? Like, maybe I'm just like tripping, but that kind of like threw me.
All right, from the immediate presence of another, meaning that if I break into your house and steal your laptop and you're not there, I've committed a crime, but I hadn't committed that crime. Because this crime is defined as taking it from somebody or their immediate presence. It doesn't mean I can take stuff. It just means there's a different crime that I've committed.
So in other words, you have to take it with the person who's present instead of not being there.
For robbery. Right. So they've got to take the facts of the case and figure out which crime they can fit that to. That's a good question. Excellent question. Let's see. Won't worry about the last one because it's long. All right, I want to talk about one more thing that is current event, not on your quiz, but a great example of a tort in the business world. It's actually on my phone, which is recording, so let me pull it up on my. So y'all all saw on the news about the Delta plane that ended upside down.
Yeah.
So on the runway, if anybody didn't hear this, plane landed and flipped over and skid down the runway. Nobody died. This is in the last couple of weeks. So predictably, what has happened already is that we got lawsuits filed. Okay, of course. And they are civil suits. They're filed in tort law for negligence. So talk about that for a second. What would be the duty of care that the airline or the pilots have? Say it, Ms. Lagon. Safely fly the plane, right? Safely land the plane. But we could expand that to make sure that your pilots are all trained properly, that they are trained in landing in icy or whatever the conditions are. Make sure that the crew is trained properly in these types of things. So one of the lawsuits is seeking damages. Remember, in tort law, we're suing because we want to be compensated for a loss or something that's happened. So they are seeking compensation due to physical and emotional injuries and economic losses. All right. Physical injuries, not that hard to prove. I was taken to the hospital. I broke my leg. Here's my medical bills. Here's the work I missed, whatever it is. Emotional injury is much harder to prove, right? I read where one guy was like, I was skidding down the runway upside down. I mean, I was pretty sure I was going to die. You know, that's tough to calculate what those emotional damages are, right? The lawsuit also claims that the crew violated numerous domestic and international airline industry standards, which could be an example of administrative law. So we might have like some federal executive agencies that are making these safety regs that have been violated, which that also made me think about this crew out here in the hallway. I'm sure there's some OSHA regs that are being violated. I just feel like. I don't know for sure, but I would bet that there are. Also, from a products liability standpoint, the article says that experts have credited the design of modern passenger jets as one of the reasons that everyone survived. That these jets now have fuel tanks in the wings designed to break off in a crash, and seats and seat belts that are designed to withstand impacts of up to 16 times the force of gravity. So that the fact that no one died is great. But had the design of the plane not been what it was, we could be looking at some products liability lawsuits too. You know, why did you design this plane with fuel tanks that don't break away in crashes? Or, you know, you've designed these seat belts that don't really withstand anything that might happen if we roll over on the runway. So thought that was an interesting bit of lawsuit that maybe Delta avoided. Delta could not be reached to comment. Delta has already offered $30,000 to each passenger on the flight. And the spokesperson for their airline said that payment has no strings attached and does not affect rights. So you can take the 30 and still sue. Ethan.
Could the pilot technically sue? I mean, if it wasn't his fault and like the plane just.
Could the pilot sue? That's an interesting question. Could the pilot sue Delta? I mean, he'd have to find somebody who's was negligent besides him. He's the one flying. So, I mean, but Ethan, it's not a bad question. Maybe he could say I wasn't trained right. I don't know. I saw a picture and it looked like there was snow. So I'm not sure.
Could it be if they sit by it, it's like this is like cause like so it's like snow or like icy runway that could be like they could shift the plane over to the airport without maintaining.
That the air traffic controllers should not have let us land, or if we're thinking along negligence lines, they hadn't properly de-iced the runway, or they hadn't scraped it, or whatever it is they do.
I didn't hear about anybody else crashing.
No, didn't hear about it. That's a good point. But yeah, so that's a great point, Michael. When something like that happens, you would look around and see who all was careless. I mean, who all didn't uphold their duty of care? Who all was negligent? And it could very well be that there's multiple instances of negligence. For sure. So that's a real life example of tort in the business law context. That's going to set Delta back a little bit. But it also strikes me too is, I don't know the facts of it, but it certainly could be that, sometimes cars crash, planes, it just happens.
I had heard rumor previously negligence in the maintenance on the.
So could be, there very well could be. Yeah. You've got a duty, obviously, like we said, to land the plane, fly the plane safely, but you also have a duty to maintain it in a safe manner so that it doesn't malfunction or skid or whatever it is. There's probably some negligence. One of the reasons I wanted y'all to do that negligence discussion question is to realize that their negligence is everywhere. It's everywhere. It's only actionable if somebody gets hurt or has damages or some sort of loss from it. But it is everywhere. You're going to walk out of this classroom this morning and see it firsthand. All right, that's all I have for today. Y'all have a quiz due Monday and a discussion question this week. Next Tuesday, we will start a brand new area of the law. So y'all have a good weekend, and I will see you then.